The story of India's uniform civil code begins long before the constitution was written. It begins with the question, can one nation have one law for all, when its people follow many faiths, cultures, and customs? In colonial India, the British applied common criminal and commercial laws to everyone but allowed personal laws, like marriage, divorce, inheritance, to differ by religion. After independence in 1947, India stood at a crossroads. The makers of our constitution dreamed of unity but feared disunity, so they struck a delicate balance. Article 44 was born, a directive principle, not enforceable in court, but a promise that the state shall strive to secure a uniform civil code for all citizens across India. Why? Because a secular democracy, in principle, should not differentiate citizens based on religion when it comes to basic civil rights. But the reality was complex. Implementing UCC was seen as interfering with religious freedom under Article 25. So, India moved cautiously. Hindu personal laws were codified in the 1950s, with the Hindu Marriage Act, Succession Act, and more, but similar reforms for Muslim, Christian, and Parsi laws were not carried out to the same extent. This created a peculiar scenario. A Hindu widow could inherit property, a Muslim woman could not challenge instant triple talaq until 2017, and a Christian couple needed 2 years of separation for divorce instead of 1. The Shah Bano case in 1985 changed everything, when the Supreme Court granted alimony to a divorced Muslim woman under Section 125 of the Criminal Procedure Code. The court also recommended implementing a uniform civil code to ensure gender justice. But political backlash from conservative religious groups led to the Muslim Women Protection of Rights on Divorce Act, which diluted the judgment. This moment marked the beginning of UCC as a political and cultural flashpoint. In recent years, the debate has returned with full force. Governments, especially at the center and in states like Uttarakhand, have set up committees to draft a UCC. Proponents argue that UCC will ensure equality, especially for women, across religions. They cite practices like polygamy, unequal inheritance, and instant divorce as examples of injustice cloaked as tradition. Critics say UCC is being pushed as a majoritarian tool, that it risks homogenizing diverse cultures, and that reform within communities is a better path than imposing a uniform law. The Law Commission in 2018 said UCC is neither necessary nor desirable at this stage, but in 2023, fresh calls for its implementation gained momentum with Uttarakhand passing a state-level version. Constitutionally, UCC is legal. The Supreme Court has affirmed that Parliament has the power to legislate it. But socially, it remains sensitive. It raises real questions. Can equality and freedom coexist in personal law? Can gender justice be religion neutral? And who decides what uniform really means? For UPSC aspirants, remember, UCC sits at the intersection of fundamental rights and directive principles. Article 14 ensures equality, Article 25 protects faith, and Article 44 dreams of uniformity. It's a classic case of balancing rights with responsibilities. Whether India adopts a full UCC or a piecemeal approach, the journey must be democratic, inclusive, and consultative. Because this is not just a legal reform, it's a social evolution. The UCC debate forces us to ask, can one law unify India without erasing its soul? The answer lies not in courts or campaigns, but in the conscience of the country.